Hey everybody, how you doing? I'm Ben Griffith, and this is the Ben Griffith Breakdown. So today we're going to be talking about the Minnesota shooting that happened in Minneapolis involving the federal ICE agent and the Minneapolis woman Renee Good. I wanted to wait a little while before we put this episode out because I just wanted to make sure that all kind of the information came out, and I feel like there's enough information out now we can talk about it in a meaningful way, and I feel like the information flow has kind of plateaued. So I'm going to try to break this down for everyone today in a very meaningful way. The reason being, there's a lot of information going around, a lot of blatant lies that are being told about this, misinformation that's being spread, and facts that are being misconstrued and misrepresented in a very deliberate way. Most of the anger that I'm seeing out of people, whether I'm talking to them in person or online, is based on things that people believe that are patently false. The media has been complicit in spreading this misinformation. And honestly, I don't think of all the issues that I've covered and, did videos on, I don't think I've ever seen such journalistic malpractice in my life. And we're going to get to that. Before I go any further on this, I want to make one thing absolutely clear. This incident involved a woman losing her life. It's a tragedy, no matter how you look at it. She left children behind. She left family behind. She left a spouse behind. And nothing about what I'm about to say diminishes that. There is a massive misconception in this country floating around right now that needs to be addressed head on. People seem to believe that if someone thinks this shooting was legally justified, then that must mean that they believed that this woman deserved to die. That is false. You can believe that a death is tragic and believe that the shooting was legally justified at the same time. These two things are not mutually exclusive. So let me be crystal clear about the purpose of this episode. The point of the discussion is not whether this outcome was sad. The point is whether the shooting was justified in the eyes of the law. Because legally, there are facts that matter and there are facts that do not matter. And there are pieces of information that they're being put out that matter and pieces of information that do not matter. We're going to get into all that. And if you don't understand the difference between these two things, everything that follows is going to sound wrong to you until you understand that. So, and when people call this murder or worse, an assassination or an execution or similar language, what they're really saying is that they don't understand the laws governing police use of force. So, before we get into it and get into the nuance of this, because there is a lot of nuance, let's clear out the really stupid stuff first. One of the claims that's being pushed is that ICE has no authority to arrest or detain U.S. citizens. This is objectively false. Under 18 U.S. Code 111, it is a federal crime to forcibly assault, resist, oppose, impede, intimidate, or interfere with federal officers, including ICE officers, while they're performing their duties. Another lie that keeps circulating is that the SUV never hit the officer. That claim is verifiably false and has been confirmed repeatedly. Even the mayor of Minneapolis, Jacob Frey, came out and said he got hit, but no harder than you would bump your hip on a refrigerator. But anyway, it's been clearly verified over and over again, and every video shows it clearly. The sad part is that everything we're discussing here could be verified in about 15, 20 minutes of basic research, but nobody wants to go out there and do it. Instead, we have people chose internet narratives over facts. And what we're seeing now is willful ignorance playing out in real time. So let's get to the facts that matter. And as we go forward, I'm going to evaluate these claims exactly the way a court would. No emotion, not emotionally, not politically, legally, right? According to the Department of Justice use of force policy, firearms may not be discharged at a moving vehicle unless, and there's two things here, but only one is relevant, so I'll read it. The vehicle is being operated in a manner that threatens to cause death or serious physical injury to the officer or others, and no other objectively reasonable means of defense appears to exist, including moving out of the way of the vehicle. There are two things in that policy that matter. One, The vehicle must be operated in a way that threatens death or serious bodily injury. That absolutely happened. It cannot be contested. Second, there was no other objectively reasonable means of defense that appeared to exist, which include moving out of the path of the vehicle. This brings us to our first major inconsistency in the narrative. There are three claims that are being made about this subject. Number one, the police officer placed himself in the front of the vehicle. Number two, he didn't try to get out of the way. Number three, he wasn't legally allowed to be in front of the vehicle. So let's take these one at a time and let's address the first claim. The officer placed himself in front of the vehicle. This is critical. And we're going to go back and watch the video because the officer did not put himself in the front of the vehicle. He was standing next to the vehicle and the vehicle backed up at an angle and the driver placed the vehicle in front of the officer to the contrary. So let's go ahead. Let me just bring that up really quick and go through it. So this is the video and I'm going to go ahead and play it. Right about here, the officer is standing next to the vehicle. Now, when I start this video again, you're going to see the tires moving backwards, tires turned all the way to the left, and the vehicle swings the front end around. And when it stops, the officer is in front of the vehicle. So again, the officer did not place himself in front of this vehicle. He was positioned there by the driver. So let me show you that. Backs up in front of him, bang. Now the officer is in front of the vehicle, right? And then very quickly moves forward, hits the officer, right? So I'm going to pause this. I'm going to back it back up and we're going to go through it again. Standing next to the vehicle, backs up, puts him in front of the vehicle, hits him, right? Pretty clear. I don't see how anyone could object to that logic. So again, officer did not put himself in front of the vehicle. Now the second claim. People are saying he could have gotten out of the way if he wanted to. If you say somebody could get out of the way of a vehicle if they wanted to, then you are by definition saying that they got hit by the vehicle on purpose. He could have gotten out of the vehicle out of the way of the vehicle if he wanted to is a synonymous statement with he got hit on purpose, which the argument collapses under its own logic and would never stand up in a court of law, and it's completely irrelevant. Now the third claim, that an officer is never allowed to be in front of a vehicle, right? This is also false. What the law actually prohibits is an officer creating danger. That means they can't step in front of a vehicle that is already moving, and they cannot position themselves in a position where a threat is already imminent, which in this case, it obviously was not. There is a very stark difference between law enforcement policy that discourages standing in front of a vehicle and the legal doctrine of officer-created jeopardy. These are two very, very different things, and people don't understand that. What happened here does not meet the definition of officer-created jeopardy. First of all, he didn't step in front of a moving vehicle. And secondly, as I showed you in the vehicle, he didn't step in front of the vehicle. So it's not even close. And again, let's again address this lie that refuses to die. For days and still now, there are people out there who are claiming the SUV never hit the officer. Let's be clear. The vehicle absolutely did hit him. And you can see it from every angle and every video. But here's the part that almost nobody understands. Contact with the vehicle is not required for an officer to legally fire on the driver. The only requirement is that the officer has an objectively reasonable belief that his life, the life of another officer or the public, is in danger. And guys, I'm going to harp on that over and over again as we go through this video, which means that even if he had managed to get completely out of the way, deadly force still could have been justified while he was in front of the vehicle for two reasons. Reason one, he reasonably believed she was going to hit him. Reason number two, and this is something that nobody's talked about, but I have discussed it with a number of law enforcement people that I know. If you look at the first video, not the one we just watched, but that first video where the agent runs up to the side of the car, reaches his arm in and tries to unlock the vehicle. When the car starts to move forward, if the officer in front of the vehicle believed that that officer was going to be dragged by the vehicle or dragged underneath the vehicle, he could have fired into that vehicle for the safety of his fellow officer. Either one of those alone is sufficient. Together, they make the justification even stronger, right? So if you don't believe me, let's look at the case law surrounding this, because the exact same scenario has already been litigated multiple times and the courts have been very clear. What matters is not what sounds bad on social media or the emotional claims made by the media. What matters is how judges have ruled when these exact same facts were put in front of them. So let's start with a case from 2007. Jenkins versus Bartlett. And tell me if this sounds familiar as I go through. Jenkins was the driver, Bartlett was the police officer. Here are the key facts of this case. Officers attempted to stop Jenkins during a traffic-related stop. Officer Bartlett positioned himself in front of Jenkins' vehicle. Jenkins' vehicle began to move forward. Bartlett fired at the vehicle, killing Jenkins. The plaintiffs argued the officer created the danger by stepping into the vehicle's path and then using deadly force. Sound familiar? So, the legal question in Jenkins versus Bartlett was simple. Was the use of deadly force objectively reasonable when the officer placed himself in harm's way in front of a vehicle that then moved forward? In other words, does the officer automatically lose the right to defend himself because of his positioning? Answer from the court was a resounding no. So, the officer was found not liable. The court evaluated and considered the officer's actions, and this is key. The court evaluated and considered the officer's actions at the moment deadly force was used, not with hindsight. And I think people forget that this officer had seconds, and you just watched the video, had seconds to make a decision that we've all been watching frame by frame in slow motion for days. The court explicitly declined to adopt the rule that the officer automatically forfeited self-defense because he placed himself in front of a vehicle. And here's the key takeaway from that case paraphrased. The Constitution does not require police officers to make perfect tactical decisions in tense, rapidly evolving situations. It requires only that their use of force be reasonable under the circumstances they confront. Only that their use of force be reasonable under the circumstances that they confront. Very important. So Jenkins versus Bartlett established that an officer does not automatically violate the Fourth Amendment by using deadly force against a driver after stepping in front of a vehicle. And qualified immunity still applies if the threat is immediate. If that's not enough, let's move forward to 2010. Thomas versus Durastanti. Almost the exact same case as the last one. Once again, core argument was officer placed himself in danger. The court held that the officer need not wait to be struck by a vehicle before responding with deadly force. The court again rejected the idea that poor tactical positioning automatically negates self-defense. And here's the critical part. In both Jenkins and Thomas, neither officer was actually hit by the vehicle. And yet, use of deadly force was still upheld in both cases in the court, which completely destroys the argument that whether the Minnesota officer was hit, barely hit, or almost hit. It doesn't matter. The entire narrative there collapses under settled law. So, let me say this clearly. Actual contact with the vehicle is not a prerequisite for deadly force. Anyone who says anything else is lying to you or uninformed. All that is required is an objectively reasonable belief, again, that the officer's life, the life of another officer or the public are in imminent danger. Both the Jenkins and Thomas case make that unmistakably clear. So, now let's get at just another claim that keeps getting repeated. People argue that the officer fired 3 shots and 2 of them were fired to the side of the vehicle after the vehicle had already kind of gone by him. And they say that as though it's some kind of a legal violation. It's not. There is, again, case law to support this. 2014, the Supreme Court decided in Plumhoff versus Ricard. The case dealt directly with firing at a fleeing vehicle, and the court confirmed two critical points. First, a fleeing vehicle driven recklessly is capable of causing death or serious bodily injury. And secondly, officers do not need to wait until someone is killed before acting. And here's a key quote from this case from the Supreme Court. If police officers are justified in firing at a suspect to end a severe threat, they are not required to stop shooting until the threat has ended. And quite frankly, another thing people need to know is that's how officers are trained. They keep firing until the threat stops. So the ruling means two things. One, the officer was legally justified to continue to fire as long as the threat had not ended. And the last two shots that he took were completely justified. So the argument that these shots fired after the SUP passes the officer is legally meaningless. The threat had not yet ended, and the officer was justified in those two additional shots. So from a legal standpoint, this is not ambiguous in any way. Anyone claiming the shooting was unjustified is not arguing law, they're arguing emotion. They are ignoring completely policy rules of engagement, police Department of Justice policy on engaging vehicles, decades of binding case law that has been decided on circumstances almost identical to this case in Minnesota. It isn't even a close call, and the precedent on it is ridiculously clear. So, even though all of that is true, the media is doing its best to spin this. And God, again, I have seen outlets bend issues before, but never to the extent in which it's happening now. The way that MSNBC and CNN and other liberal outlets are trying to support and justify this woman and vilify the federal officer it's mind-bending. It's absolutely mind-bending. And all the arguments that they're making, the points that they're pushing, are based on ignorance of the actual facts or of any applicable law that we just discussed, right? They talk about this incident as though there's no verified details or no legal standards and, quite frankly, no footage. Like we're not all watching the same videos. And every single point, again, that they make is emotional, right? So we've talked about what matters. Now let's talk about all the points that have been made that don't matter in this case and are strictly a distraction. And when I say they don't matter, what I mean is something very specific. I mean, these arguments would never hold up in a court of law. They don't pertain to the case in any legal way. And like we talked about earlier, this is how you have to frame it. Imagine this officer is on trial. Imagine this case is being litigated in a courtroom. For every claim you hear, ask yourself this one simple question. Would this matter in a trial? Does this have anything to do with reasonable force by a police officer? Does this have to do with the officer objectively believing that he was in danger? If the answer is no, then it doesn't matter here either. Because all that actually matters, again, is did the officer have legal justification to fire his weapon? If the point being made does not challenge that question, then it's a moot point. So let's go through a few of them. First and foremost, this one was mind-bending. The steering wheel was pointed away from the officer. Now imagine this had gone to court. Imagine the officer doesn't fire his weapon and this woman goes to court, and she would have gone to court. She would have been facing 2 counts of obstruction, fleeing police, and assault and battery on a police officer with a deadly weapon. Right? Now, does anyone believe that a reasonable legal defense would be she hit the officer with her car, Your Honor, but she was really trying hard to turn the wheel? It's absurd. It would never survive 5 seconds in a courtroom to try to convince a jury or a judge that it's okay that you hit an officer of the law with your vehicle because you were really trying hard to turn the other direction, right? It's a moot point. Next, she was really nice to the officer. People say she was polite. She was calm before the incident. So what's your argument here? That if you're really nice to a police officer, you're allowed to later run them over with your car? With as long as it happens within 1 or 2 minutes? Is that the legal theory here? There isn't one. It means nothing, right? People talk about what the officer said afterwards. They bring up the fact that, I'm going to use some harsh language here, after the SUV hit him, he said, "That fucking bitch." Means nothing. It happened after the fact. It has absolutely no bearing on whether the officer used justified force the moment he pulled the trigger. Has nothing to do with it. And honestly, I don't think there's a human being on earth who would get hit by an SUV by another person and not have some pretty strong words to say about that person. I know that if I was hit by a vehicle, I would have some pretty choice words to say about that person. But again, legally, completely irrelevant. They keep saying over and over, she was a mother. Yes. That makes this situation more tragic, but it does not factor into the illegal analysis or who was at fault in any way, shape, or form. Tragedy does not equal illegality. Let's see. Oh, there were stuffed animals in the car. Oh my God. How does this matter in any way, shape, or form? It doesn't. It doesn't. The answer is it means nothing. And it exists purely to provoke emotion, just like all of these other arguments that people make. Another thing people say, we don't know what her intentions were. We don't know what her intentions were. And quite frankly, we never will. But again, it doesn't matter. The law does not require an officer to correctly guess intent. What matters is that the officer reasonably believed that he was in danger in the moment that he reacted. That's it. Her intentions in that moment mean nothing. She barely hit him. Like I said before, people argue that she barely hit the officer. Imagine, again, going to court, hitting anybody, never mind a police officer. And do you think a defense attorney on earth would say to a judge, Your Honor, she hit this person, but kind of only a little bit? It's ridiculous, and it would get laughed out of court. If you hit him on the hip and spin him around, fully hit him or run over his pinky toe, you are still guilty of assault and battery on a police officer. And to say that you barely hit him as a defense it's laughable. The car was only going 5 miles an hour. Again, would never stand up in a courtroom anywhere. If this vehicle rolls over you at 5 miles an hour, it can still knock you down, drag you, or kill you. Tires don't become harmless at low speeds. Making that argument in court, again, would get you thrown out of court. It's stupid. So every one of these arguments has something in common. Like I said, they're all emotional. They sound persuasive, but they have no legal weight, and they don't challenge the only question that matters here. Was the officer legally justified in using deadly force? That's the only thing that matters in this whole thing. And if an argument doesn't address that, it doesn't matter, period. Period. Right? So, simple fact is this. This chaos in Minneapolis right now are a result of a couple things, right? Not confusion, not lack of information, two very specific causes. One, lack of local law enforcement cooperation. ICE needs significantly more resources in Minneapolis. Why? Because local law enforcement does not cooperate with ICE. And in fact, they are not just unwilling, they are forbidden from doing so. That makes ICE's job far, far more difficult. And any job on earth, when it becomes harder, it requires more manpower and more resources. That's reality, regardless of what you're doing. The second point is, state and local politicians, along with other prominent voices, are openly encouraging people to interfere with ICE operations. They are encouraging civilians to put themselves directly in harm's way. What these people don't realize, or maybe they don't care about, is that they're using these individuals as cannon fodder. They send these people out knowing that eventually someone will get hurt. You can't go out and tell people, put your bodies in front of ICE agents and not think that someone's going to get hurt. And when it does inevitably happen, they attempt to martyr them, all while demonizing ICE officers who are simply doing their jobs, right? It's manufactured outrage, and it accomplishes one thing. It agitates the people of Minnesota. It inflames emotions. It creates chaos. And when the investigation here inevitably finds that this officer committed no wrongdoing, Minneapolis is going to burn again. And that will rest squarely on the shoulders of the politicians that knowingly pushed this false narrative on the community. They knew it was false when they said it. And listen, there's no way they didn't know this was false. You don't think Jacob Frey and Tim Walz have access to legal representation for the state? There's not a lawyer on earth worth their salt who would look at this and say, yep, that was absolutely murder. So either they didn't get legal representation to get an opinion on it, or they did and they're saying something that they know was false. And here's another simple truth. If this had been a Minneapolis police officer in the same exact situation, this would have been a blip on the news cycle. We would have never even heard about it. Minneapolis would not be in chaos right now. The reason it isn't being treated that way is completely political. And the way you can tell it's political is how people try to justify it. Everything is based on emotion. Nothing is based in fact. So let's be honest about something else. Even if this officer had not fired his weapon, if he had been run over by this woman, the same people would still be siding with this woman. There are zero outcomes in which this ICE agent is innocent in their eyes. Zero. The simple fact is this. This situation has one defining question that I keep going back to. Was the officer justified in pulling the trigger, or was he not? Everything else is emotion. Everything else is politics, and everything else is a distraction. So, unfortunately, there are people out there who will watch this video. They will see clear, undeniable, empirical facts and still try to justify this woman's actions, which points to something much deeper. There's an ideological sickness in this country, one where logic is consciously abandoned in favor of emotional outrage. And I don't believe there's an easy cure for it, honestly. And I hope I'm wrong, but every instinct tells me that I'm not, and that this situation is going to continue to get worse as we go. And guys, I guess I'll leave it there. As always, questions and comments in the comment section below. And again, thanks for tuning in. Appreciate it.